morning, everyone, and welcome to our annual roundtable on the Supreme Court. And thank you for joining us this morning. I'm Joyce Ball. I'm a professor in the Political Science Department at Central Michigan University. And I'm joined this morning by four distinguished panelists and friends. We have first to my immediate left, Dr. Ashlyn Kirsten, Department of Political Science at Western Michigan. Next to her, Dr. Mark Hurwitz, also from the Department of Political Science at Western Michigan. Then standing and passing some things around for you, Dr. Chris Smith from the School of Criminal Justice at Michigan State University. And last but not least, we have a new guest to our panel this year, Dr. Scott Johnson from Frostburg State University in Maryland. This morning, we're going to actually be going in a couple of different directions. We're going to take a look back and a look forward. We'll talk a little bit about what happened during the last term of the court, the 09-10 term, and also looking at what's been happening and what's going to happen this term, which began just about 2.5 weeks ago. And after their remarks, then we're just going to open it up and you all can have questions and we can have some dialogue together. And I think the order we are going to go is Chris is going to go first and talk about some of the criminal justice cases and also some work he's done specifically on his book on Justice John Paul Stevens. He's had the privilege of interviewing the justice twice now, and he has some very fascinating stories about that. And then we'll move on to Scott, who's going to talk about the, as people call it, the gun case, the McDonald City of Chicago case. And then on to Mark Hurwitz. Mark is going to talk about the First Amendment, the funeral protest case, as we might call it, and maybe even another case. And then we're going to close out with Dr. Kirsten. Ashlyn is going to talk about a couple of cases this term, one having to do with DNA testing with respect to criminal defendants' access to that, and then the other one on the whether or not states can ban the sale of violent video games to young people. So, Chris, it's on you.
I handed out, as I do every year here, a table that is sort of a simple compilation about the most recently completed term and criminal justice cases. I do an annual article on this. This year, one of my colleagues at San Diego State got a little creative and made the tables a little less simple than usual. But basically, just for your interest, the table one, as an overview, would not be very different than prior years in the sense that it reminds us that even with a Supreme Court that leans in a conservative direction, and liberal and conservative, of course, are difficult to define, so we simply say sort of support for individuals versus support for government. But as we've had in the past, you know, a majority of conservative outcomes, but still a substantial percentage of cases where the Supreme Court supported individuals, and sometimes to sort of people with just general familiarity with the court, that comes as a surprise. But that's true year in and year out. The percentages may differ somewhat. The other thing we see is there'll always be anywhere really from 25 to 40% of these criminal justice cases that are unanimous. So there are issues that come to the court that even as these justices have great disagreements with each other, they do have a consensus on certain things that come to the court. But we also see substantial disagreement, which I tend to define as anytime you have three or four dissenters, and I think that's pretty characteristic of what we've seen in the past too. So in some respects that wasn't very different. If we look at the conservative voting rates, and here I just call your attention to the third column on the right, where we get a kind of ranking in effect of, liberal to conservative on that set of criminal justice cases. And we like to take out and look at non-unanimous cases so that there is some disagreement in these cases. And of course, what's interesting here is that while in many past years, Clarence Thomas was very often the most conservative justice, he is now being outflanked to the right by Justice Alito on criminal justice issues. So if you think in terms of Stevens departing, the most liberal justice on these issues, the right sort of being even more conservative with Alito outflanking Thomas, it'll be interesting to see how Kagan fits in here. Is she going to end up being more like Sotomayor and Breyer, not as liberal as Stevens, or where will she be? That's one of the things we'll be looking for next year, even though it'll just be a one-year snapshot. Table 3 gives some sense of sort of opinion distribution. Most of these things were assigned by Justice Roberts. I guess what is notable here is how few opinions were assigned to Justice Alito. And in some respects, this may be similar to the career of Justice Thomas, that when you have justices whose views are markedly at one end of the spectrum, even a conservative Chief Justice may be reluctant to give them many majority opinions, especially on controversial issues, for fear that they'll write it in too much of a I don't want to, extreme or ideological or unique fashion that may, send somebody like Kennedy in the other direction. And then with the interagreement tables, it was interesting to see high rates of interagreement between Breyer and Sotomayor. Thomas and Scalia, you always get high rates of interagreement. With respect to criminal justice cases in the past term, let me just mention two things that are notable. One, there was a set of 3 Miranda decisions this last year, and 2 of them in particular, I think, are the source of some controversy from the viewpoint of defense attorneys. One of them had to do with sort of greater flexibility in the way that Miranda rights are read, and the Supreme Court approved a reading of Miranda warnings that, in the exact words themselves, did not specify that the individual could at that moment demand an attorney. The Supreme Court was satisfied with that because it was a more generic sounding warning. I think they're sort of saying, well, you should have understood, even if it wasn't as specific as it might have been. And the other one was that a defendant who was silent in response to police questioning and then after some hours said something was not regarded as having asserted his right to remain silent, as they kept questioning him and he refused to speak. And the Supreme Court came up with this decision that said, in order to assert your right to remain silent, you have to speak and say that you're asserting your right to remain silent, which Justice Sotomayor, condemned as sort of said turns the whole principle on its head, that in order to have a right to remain silent, you must speak. And I think that for commentators, you look at that and say, to what extent is this given even greater flexibility to the police? Is this going to encourage them to be even more creative, even more persistent in ways that would have been unacceptable in much of Supreme Court history since 1966? The other one that I would note that is a source of controversy has to do with the Supreme Court's decision that juveniles cannot be sentenced to life without parole for crimes that are not homicides, because Florida was sending juveniles to prison with life without parole for robberies and things like that. And it was a close case, but it goes to a very divisive debate in the court about the meaning of cruel and unusual punishment, which is really a debate between the originalists and those that take a more flexible view of interpreting the Constitution. In July, I had the privilege of being invited to the Supreme Court to interview Justice Stevens again. I had gone in 2006. This time I was probably better prepared. I had my recorder. I took a camera so I could get a souvenir photo with him. And we had a very, memorable for me 2-hour one-on-one conversation about a lot of things. But, one of the topics that I focused on was cruel and unusual punishment, and the fact that he has been one of the outspoken advocates of using the standard that's existed since 1958 that interprets cruel and unusual punishment according to evolving standards of society, and that, of course, is just reprehensible to an originalist because you have this constantly moving standard and you have judges in positions of trying to say what are society's values today. And so we get these significant debates within the court about how do we approach these things. And I just wanted to note that Stevens seemed to fire some final shots in his final term about some issues. And let me just quote a brief thing he wrote in the juvenile detention thing to get his last word in on the Eighth Amendment, or what we thought was his last word, where he said, "Society changes, knowledge accumulates, we learn, sometimes from our mistakes. Punishments that did not seem cruel and unusual at one time may, in the light of reason and experience, be found cruel and unusual at a later time. Unless we are to abandon the moral commitment embodied in the Eighth Amendment, proportionality review must never become effectively obsolete. While Justice Thomas would apparently not rule out a death sentence for a $50 theft by a 7-year-old, the court wisely rejects his static approach to the law. Standards of decency have evolved since 1980. They will never stop doing so." A strong, short, brief, to the point final shot against the originalists. But it wasn't his final shot, because then he just gave a speech in October to the National Association of Defense Attorneys, and this was somewhat unusual, where he actually used that speech to critique the originalists' approach to cruel and unusual punishment with respect to proportionality review, which makes one think that, unlike Justice O'Connor, who goes around and gives speeches about the importance of civics and how electing judges is a bad thing, Stevens, as a retired justice, seems to still want to be engaged in debates about the meaning of the Constitution and the preservation of his approach to interpretation. The one other thing, let me mention about my interview with Stevens is, Scott's going to talk about, the gun case, but as I read Stevens' dissent in that McDonald case about Chicago gun laws and where we're going to incorporate the Second Amendment, I said to him in the interview, it seemed to me that Stevens' dissent looked like a final lecture by a professor, like someone who's leaving the stage, leaving the podium, and wanted to make a final, clarifying, value-emphasizing, philosophy-emphasizing opinion to let people know this is what I've been about. Because I highly recommend reading that opinion, because he talks a lot about a theme that was important throughout his career, but that he didn't always stop and emphasize so much, and that his preoccupation with the concept of liberty in the Constitution and the meaning of liberty. He has, for example, criticized identifying a right to privacy in the term due process. So he thinks Roe versus Wade, for example, made a mistake in talking about privacy as being from due process. He would have said privacy is part of liberty, right? Or that liberty encompasses privacy interests so that you actually focus on a substantive right in the Constitution, liberty, rather than leaving yourself open to people saying, but the word privacy isn't anywhere in the Constitution, to which he would say, but liberty is, and choice about abortion is a part of liberty. So he emphasizes that, and he also identifies himself with the second Justice Harlan's approach to applying rights to the states, which I would regard as a non-incorporationist approach that doesn't depend on the Bill of Rights at all. And I was frankly very surprised at that, and he was a little surprised that I was surprised, but I was pointing out to him that his conception of liberty is so much broader than the conception that Justice Harlan articulated, that he really isn't like Justice Harlan. And what he's clarifying in his opinion is that his methodology is the same as Harlan's, but his conception of liberty is actually much broader than what Harlan's was when Harlan was writing about these issues. So, you know, it was a really important opinion. The one interesting thing he said to me was when he wrote that opinion, because, you know, they haven't really done an incorporation case. This was like his one shot in his career to kind of talk about that issue, because they haven't done much since '68 with that, and he came on in '75, was that when Scalia, if you read Scalia's concurring opinion in the case, Scalia's opinion is totally an attack on Stevens and totally attack on Stevens' opinion. And Stevens said to me, you know, my law clerks were saying to me, you need to expand your dissent and respond to what Scalia is saying. And he's saying, you know, I debated Scalia on this in the Washington gun case in Heller. But he said, my clerks convinced me, yeah, what the heck, one last joust with Scalia. We'll go toe-to-toe with him one more time. Although his October speech this year is a criticism of Scalia. So it's very interesting. But anyway, let me stop there. And so later on, if people want to ask me questions about my time with Justice Stevens, I'll be happy to talk about that.
Thank you. Scott?
Okay, I'm going to talk about the McDonald versus Chicago decision that was handed down this summer by the Supreme Court. And it was built basically on the D.C. versus Heller case, which was a 2008 case which established the right to bear arms as an individual right for the first time. I think back in 1939 there was a case, a Second Amendment case, where the Supreme Court said it was a collective right. And now there's this movement to deal with the Second Amendment in terms of whether it's an individual right and incorporating it upon the states. Well, the McDonald versus Chicago case involved Otis McDonald. He was a 72-year-old African-American man who lived in a crime-riddled area of Chicago, and he wanted to have a handgun to protect himself. And he joined up with the Illinois State Rifle Association, made some friends there, and decided he wanted to challenge the ban on handguns in the city of Chicago. There was also a similar ordinance in Oak Park, Illinois, as well. But essentially, I mean, it dealt with registering handguns and re-registering handguns annually, but for all intents and purposes, it really did ban the private ownership and possession of handguns in Chicago. There are two issues that were addressed during the oral arguments of the Supreme Court. Should the Second Amendment be incorporated onto the states? Should it be nationalized, and the states and local governments should have to recognize the right to bear arms as an individual right, because the D.C. case was obviously federal jurisdiction? And also the issue of should the Privileges and Immunities Clause, which has been interpreted very narrowly in cases such as the slaughterhouse cases, should that also be used perhaps to nationalize the Second Amendment right to bear arms? Well, to cut to the chase, the Supreme Court voted 5-4, and it was an ideological breakdown where you had the conservatives, Alito, Kennedy, Thomas, Scalia, and Roberts voting in the majority to nationalize the Second Amendment, and the dissenters were your liberal bloc, Stevens, Breyer, Ginsburg, and Sotomayor. Now, Alito rejects the Privileges and Immunities Clause argument that came up during oral arguments, and he focuses on the modern substantive due process argument, which is typically how parts of the Bill of Rights have been nationalized onto the states. Because initially, the Bill of Rights basically said Congress shall pass no law, so it referred to federal power. But then over time, we see, particularly in the 1960s, this march of incorporation, which some people call the Second Bill of Rights, which I think you could argue is more important than the original Bill of Rights, applying all those freedoms to the state and local levels, particularly if a state didn't have certain freedoms listed in their state constitutions. Alito writes the majority opinion for the court, and he relies a lot on the history of incorporation, talking a lot about different cases such as Hurtado versus California and Gitlow versus New York. But for the most part, he makes the argument that the Second Amendment is an individual right to bear arms and is a fundamental freedom. It's something that's deeply rooted in the traditions and history of the country, and it should be given strict scrutiny. It should be given the highest level of protection based on the argument that people need to be able to defend themselves in their homes. So it was really based on this self-defense argument for the most part. Now, we have some interesting concurring and dissenting opinions as well in this case. As Chris pointed out, Scalia has a very interesting concurring opinion where he attacks Stevens pretty much throughout the whole concurring opinion and basically calls Stevens' approach to due process and substantive due process as being very selective, that he's picking and choosing which freedoms he wants to apply to the state and local level. So it really is an attack on Stevens for the most part. Thomas probably has the most interesting, if you want to call it that, concurring opinion where he wants to return to a more originalist approach of the Privileges and Immunities Clause and use that to actually apply the Second Amendment to the states. The dissenting opinion, Stevens relies largely on Palco versus Connecticut, Justice Cardozo's opinion, where Cardozo established selective incorporation, the standard that those rights that are implicit in the concept of ordered liberty, those most fundamental rights are the ones that should apply to the state and local governments. So Cardozo makes the argument some rights are more important than others to establish due process, and those should be given priority. And Stevens makes the argument the Second Amendment is not one of those freedoms that actually should be given protection at the state and local level. Breyer's dissent is much more practical or pragmatic, if you will. He says there's no popular consensus that the right to bear arms is fundamental. He says there's an ambivalent relationship between the right to bear arms and whether or not it provides security for people, because it obviously provides a lot of harm in society. He makes a strong argument that the state and local governments are laboratories of democracy, and each state and local government should deal with gun rights as they see fit based on their cultures. And what was fascinating to me about the case, reading it for the first time, was the fact they really didn't make a decision. They didn't strike down the Chicago handgun ban as unconstitutional. What they did basically is they sent it back down to the Seventh Circuit, and they basically said, okay, here's our standard. The right to bear arms is a fundamental freedom, and you need to justify a handgun control law, you need a compelling state interest, and the law has to be narrowly tailored to serve that compelling state interest. So there's a lot of ambiguity and vagueness about the decision, and I think what we're going to see in the future is that just hundreds, if not thousands, of lawsuits filed in state and local communities regarding gun laws that exist. And obviously this is going to be a lot of work for attorneys to sort of flesh this out, but I think it's the beginning of a lot of cases that will go into federal court, maybe even to the Supreme Court. Now, I want to emphasize, while Alito did establish this as a fundamental and individual right, he did not say it was an absolute right, and he answered, obviously, some reasonable and basic questions about, obviously, if someone is mentally ill or someone's a felon, they shouldn't have the right to own a handgun. But the types of questions that will have to be addressed in the future, I can just name a few of them. Does the right to possess weapons for self-defense extend outside the home, to the car, to the workplace? What if there's a child in the home? When do registration requirements become severe to the point where they amount to unconstitutional ban? What if someone's a drug abuser or an alcohol abuser? So what we're seeing is just a whole Pandora's box opening up with the DC versus Heller case and the McDonald versus Chicago case. Just a whole host of unanswered questions that probably will get answered sometime in the future, but my guess is it'll take a long period of time for the local and state courts to, I think they're really unsure about how to judge the right to bear arms and some of the handgun control laws that exist. So that's something they're going to have to deal with. And Breyer makes the argument that state and local judges are not equipped to handle these questions concerning empirical questions about, should handguns be legal, or should they be prohibited, or should they be controlled? So it was a really interesting case in the sense that I think there's going to be more cases. I think there's going to be much more litigation in the future as a result of this, and this is clearly just a beginning and not an end to understanding what the Second Amendment means.
Thank you. I'm going to cover two First Amendment cases. The First Amendment, and they touch on a few other issues as well, too. One from last term that's already been decided, and one from the current term where there's been an oral argument but no decision just yet. The first case from last term is U.S. v. Stevens, having nothing to do with Justice Stevens, but the person's name happens to be Stevens. And this was a case that got some extra notice, perhaps, because of some issues that were going on. This was a case about animal cruelty. And, of course, we all know about the Michael Vick dogfighting notoriety and things that went on with that. Well, what happened here, basically, was there was a federal law that was signed by President Clinton in 1999, and that law made it a crime to knowingly sell depictions of animal cruelty for commercial gain. And when President Clinton signed it, he basically said, I have some misgivings about the constitutionality of this law. I think it's somewhat problematic. What he left unstated was, but a Republican Congress passed it, and I don't like vetoing things that they pass generally just to prove that I'm a moderate, and so that's what he, and so he signed it. And I'm not being facetious. This was actually a pretty typical kind of pattern that President Clinton did, particularly late in his term. So anyway, we have this law. It's been on the books for a number of years, and you've got this guy, Robert Stevens, who sold videos of dogfighting, and he was convicted under this law. And but the Third Circuit Court of Appeals reversed that conviction, saying basically that the type of activity he was dealing with was known as protected speech. And when the case made it to the Supreme Court affirmed that decision, saying the law was unconstitutional on its face. And it was a very strong decision in favor of the First Amendment. Chief Justice Roberts wrote for an 8-to-1 majority. As we'll see, Justice Alito was the sole dissent, and so he's not becoming just the most conservative justice on criminal justice issues, but he is on issues here as well too. Although Alito generally is very supportive of other kinds of religious freedoms and things under the First Amendment. Anyway, what Chief Justice Roberts said was the law, simply put, was overbroad. And it included activities that may be protected and may be not protected. And simply put, the Supreme Court refused to put a specific category of speech outside of First Amendment protection. And when he said that the law was overbroad, they said, you know, there might be some of these types of videos that are just simply, you know, not protected, but the way the law is written, it also could include hunting magazines, which sell far more in terms of commercial success than these animal cruelty videos. And if you're going to, I mean, the classic case of an overbroad statute is when you sweep in protected kinds of issues with what might be unprotected. Now, when the United States argued this case before Supreme Court, they made the argument that these types of videos have minimal social worth and the speech is basically worthless. But the Supreme Court disagreed. And in one of those you know, kind of famous statements that we can say, the Supreme Court said this a number of times on the First Amendment. It's not always consistent that way, but it did here. It said, the First Amendment means that the government has no power to restrict expression because of the message, its ideas, its subject matter, or its content. And again, this is a type of statement that harks back to some of the strong First Amendment kinds of protections the Supreme Court has issued in the past. Simply put, this case did not fit into one of those exceptions for First Amendment protection. Those exceptions the court has staked out in the past, issues of child pornography, obscenity, fraud, incitement, and speech that's integral to criminal conduct. They said this was not that kind of a case, and they weren't willing to carve out a new exception. And they said here the law presents a criminal prohibition of alarming breadth. In other words, this was a very, very broad kind of statement. Since the law was too broad, the Supreme Court said this was unconstitutional. But Chief Justice Roberts did leave open the possibility that a more narrow law could be constitutional. Just this one was far too overbroad. As I said, Justice Alito wrote a sole dissent, and very simply he said this particular federal law was not intended to suppress speech. Instead, it was simply designed to, and this is a quote, prevent horrific acts of animal cruelty. Alito was most concerned that the majority decision would allow a resumption of crush videos, basically these types of videos that depict a combination of sexual domination and animal cruelty, and basically this federal law pretty much stopped most of that, and he was worried that there now would be a proliferation of these types of issues. But Alito's decision was a sole dissent. The majority opinion in the Stevens case, Supreme Court made a strong point of not allowing the government to suppress a particular kind of speech, particularly based on that content. The question then becomes, how strong is the Supreme Court going to be in the future on First Amendment kinds of issues? Is it going to continue on this path of strongly supporting the Supreme Court, not just because it was a strong majority here. All but one of the conservatives agreed with the liberals here, but of course we now have Justice Stevens stepping down and Justice Kagan taking a seat in his place. So it remains to be seen what's going to happen. And one of the places where we might get a little bit of an idea about this is a highly controversial case that was argued just a few weeks ago before the Supreme Court. And this will give us an opportunity to see how far the Supreme Court is willing to go to protect the content of speech, however distasteful that speech may be. And this, of course, is the case that's known as Snyder v. Phelps. This is where you have members of a small church, the Westboro Baptist Church, who have been protesting at military funerals. And they specifically went to the military funeral of an Iraq Marine, a Marine who was in Iraq, and he had died. And they went to his funeral, and they held up signs that were that most of us would believe are distasteful at best. I mean, things like "God hates the USA," "Thank God for 9/11," and similar phrases and all. And what happened was, and each time they go through these protests, they get a permit. They find out where the military funerals are going to be. They get a permit for these things. They go to the place. They're nowhere near anywhere where the actual funeral, the church is going to be. It was reported in this case that they were right by the entrance of the cemetery. In fact, they weren't. And in fact, the father of the deceased Marine said he never even saw. He didn't even know about it. He never saw them. He found out about it when people told him later that day, and he watched the news that night. In any event, what happened was the father, this guy named Snyder, sued the church, and actually sued the individuals in the church for intentional infliction of emotional distress, which is a basic tort that is an interesting tort, but basically it's a tort that's designed by the states to protect the privacy of its citizens. And Snyder won. He won a jury award that was about $8 million in damages. Nearly $3 million in compensatory, excuse me, it was $8 million in punitive damages and about $3 million in compensatory. So an $11 million damage suit as well. Completely. Now, for those of you who don't know what intentional infliction of emotional distress is, it's different in every single state, but generally speaking, the plaintiff has the burden of proving basically that the defendant acted either intentionally or recklessly, that the defendant's conduct was extreme and outrageous, that the conduct must be the cause of the emotional distress, and that the emotional distress must be severe in nature. And basically, the jury agreed that all of those issues were exactly the case. And I'd say that was probably a reasonable jury decision looking back on it, except for the one part where it said the conduct must be the cause of the emotional distress. The guy just buried his son. There might be some other causes of emotional distress out there as well, but in any event, I still think it was a reasonable jury decision based on the law of extreme intentional infliction of emotional distress. In any event, the church then appealed that $11 million jury verdict, and the Fourth Circuit Court of Appeals overturned, held that the church's statements were protected under the First Amendment. And basically, they should be protected, first because they are known as rhetorical hyperbole, as opposed to verifiable fact, and because the statements address a matter of public concern. It gets to the Supreme Court, and the Supreme Court case is going to implicate all these issues on free speech as well as issues on the law of intentional infliction of emotional distress. And again, the church is protesting here basically because they're trying to say, we think the U.S. military is doing some bad things here. Not because they think that the U.S. military shouldn't be fighting in places like Iraq and Afghanistan, but basically because they think the United States is promoting and having promoting homosexuality and things like that. And so, again, some of these signs: God hates the USA, thank God for 9/11, America is doomed, Pope in hell, fag troops, you're going to hell, Semper Fi fags, thank God for dead soldiers. I mean, some real distasteful kinds of things. What also happened in this case, they published on their website, and they called it an epic poem called The Burden of Marine Lance Corporal Matthew Snyder, which basically claimed that the father taught his Marine son to defy his creator. He raised him from the devil, taught him that God was a liar, to worship false idols. That was the part about the Snyder family. Snyder family was Catholic, and so this was basically, some people have labeled this, another instance of cyberbullying. And so we don't know what's going to happen. The Supreme Court's going to determine whether or not the Snyder's interest in suing for harm caused by disruption to his son's funeral is outweighed by the church's First Amendment rights. At this point, it's really hard to gauge by the questions the justices were asking at the oral argument. I don't think this is going to be a unanimous or near unanimous decision, but the coalitions may not necessarily be along traditional ideological lines like the McDonald case was. I mean, this could be one of these hodgepodge types of decisions. One interesting thing that I just want to end in, Justice Holmes dissented in a famous case in the 1920s on the First Amendment. And here's what he said about this. He goes, "If there's any principle in the Constitution that more imperatively calls for attachment than any other, it is the principle of free thought, not for those who agree with us, but freedom for the thought of that we hate." And that's kind of what the Supreme Court is up against right now. Is it willing to protect the speech of a group, for the most part, whose speech that most of us, for whatever reason, don't agree with? And it'll be interesting when the Supreme Court comes out on this. Thank you.
One clarification on that. The Phelps Westboro Baptist Church, they're not claiming that the dead soldier was gay.
Oh, actually, and that was one of the arguments. I mean, the father was actually, in some ways, it's interesting. There was a little bit of homophobia here. They were saying, "Hey, my son's not even gay." Trying to say you're maligning, you're slandering my son. He's not gay, and the church said, "We don't care." Because the fact is, he's part of the military, where most people believe that the don't ask, don't tell rule is actually a rule that seems to hinder the rights of gay people. The church believes that that's actually a way of allowing homosexuals to just be completely pandemic throughout the military. So, and not just the military, but the society itself. So again, you get a lot of cross-cutting issues on this one as well too. Thanks.
I'm going to build on some of what Dr. Hurwitz just talked about, the Stevens case. I thought I'd start off with the Schwarzenegger versus Entertainment Merchants Association. This is a case based on the a California statute from 2005 that prohibited the sale of violent video games to minors under the age of 18. There were several rules for this. First, if a reasonable person could find that the violent content of these videos would appeal to a deviant or morbid interest of minors, was patently offensive to prevailing community standards about what would be suitable for minor children, and 3, would cause the game as a whole to lack any serious literary, artistic, political, scientific value for minors, much the standard that we have for obscenity prohibitions. I love this case because of its irony. You got to appreciate this. Because Arnold Schwarzenegger is the governor of California, he is, of course, the lead plaintiff in this case. This is the one-time actor for, I know there's several youngsters in here, and you might not know this, the one-time actor who slew thousands and thousands of baddies in a series of blood-drenched horror flicks and other action-packed flicks like The Terminator, Commando, and Conan the Barbarian. So presumably Arnold Schwarzenegger knows a lot about the violence in which he wants to prohibit or limit to minors. So in other words, why I find this so interesting is Conan the Barbarian is lecturing the American public about how to prevent violence in videos. I just find that hilarious. It's just so many different levels. The respondent industry group, so this was the Entertainment Merchants Association, challenged the California law for violating free speech of the First Amendment. They said that they should be able to, much like the Stevens case, they should be able to promote and produce videos of their choice. They should not be limited. If they are limited, that would be a violation of their free speech rights. The state of California Schwarzenegger, again, Conan the Barbarian. We'll just refer to him from now on as Conan. One of the briefs from California said, quote, "People shot in the leg will fall down and crawl. The player can then pour gasoline over them, set them on fire, and urinate on them. The player's character makes sardonic comments during all of this. For example, urinating on someone elicits the comment, 'Now the flowers will grow.'" So the Merchants Association, the Video Merchants Association, assert that a restriction on the sale, the video, the rental, or the production of these violent video games restricts their First and 14th Amendment freedoms of expression and equal protection of the laws, and therefore is unconstitutionally vague. Lower courts have tended to agree with them, and there is some procedural history here. The district court found in favor of the plaintiffs and prevented the enforcement of the law. The U.S. Court of Appeals for the Ninth Circuit affirmed that violent video games did not constitute obscenity under the First Amendment, which, of course, if it had constituted obscenity, could be banned. The state did not have a compelling interest in preventing the psychological or even neurological harm. There were physicians that filed amicus in here claiming that there would be neurological changes that would take place in small children upon watching these videos over extended periods of time. And then thirdly, the appellate court said that even if a state had a compelling interest, the law was too broad, too unconstitutionally vague. So we will find out sometime in the next couple of months whether the First Amendment bars a state from limiting the sale of violent video games, building on the Stevens case, which doesn't have anything to do with Justice Stevens' case. And what the standard of review will be for limiting the sale of either video games or, in the Stevens case, we know the actual movies, because Stevens was actual movies of, it wasn't just little video clips. And here we're talking about usually animated characters, so there may not actually be people involved, but the animated characters are so real in your view that it could, I guess, change children into believing that they were actually real people. So should prove to be an interesting case, and see if Conan the Barbarian wins or not.
Live in your world, play in ours, right? So.
Yeah, I guess. The final one that I just wanted to talk about real briefly is the Skinner case. This is Skinner versus Schweitzer. It's a death row inmate case out of Texas. A murder took place in 1993 between of Skinner's girlfriend and two of her adult sons. Skinner claimed that he was in the house at the time of the murders, but he was in a codeine-enhanced drunken stupor and missed the whole murder. So he woke up from his codeine, alcohol-enhanced kind of coma, and they were dead. He didn't have anything to do with this. For 10 years, he has sought DNA evidence that he says could prove him innocent of the murders. In March, less than an hour before his scheduled execution, the court in Texas granted him a stay. So he was very, very close to being put to death. And the typical question in this is, why doesn't the state of Texas just just test the evidence that you'll answer the question whether he's guilty or not? Why don't we just cut to the chase and get to the end of the story? The prosecutor in Texas is the one who's being sued. Skinner is suing the prosecutor in the case. The prosecutor says that Skinner simply made his request too late. There's nothing wrong per se with his request, but he should have done it prior to now. She says that the testing would be pointless because additionally no item of evidence exists that would conclusively prove that Skinner did not commit the murder. And then there's some procedural questions. Skinner filed this claim against the prosecutor under a 1983 civil rights claim. The prosecutor is saying, I don't have anything to do with this. This is about the laws of the state of Texas, not my own personal behavior or activities. You should have filed a habeas claim because you're being held illegal. So it's all about procedural matters. And like I said, most of the public is saying, just test the DNA, and then this does not have to go all the way through the court process. So we'll see what the Supreme Court ends up saying the state of Texas shall do. Of course, as you probably know, Texas has the dubious distinction of having the most people on death row and the most success with executions. And so they have a number of cases that are filtering their way up to the higher courts, largely on procedural matters.
Thank you.
Ashlyn, if I could just ask, the Supreme Court said a number of years ago that innocence is not an appealable issue. In other words, once you're found guilty, you're guilty, and even if there's evidence that comes up afterwards that proves you innocent, there's no guarantee that you can get that evidence in. And Texas, I believe, has a rule that says you have to file any kind of claim that shows you're innocent within 30 days after conviction. So that's part of it. Do you think that this case has the ability or the potential to go back on that innocence is not an appealable, issue kind of
Well,
discussion?
I mean, certainly it would change public opinion dramatically if there was DNA evidence that indicated he really did not commit the crime. I don't see this going anywhere. I mean, it sounds to me like originally there was quite a bit of DNA evidence available, and then the prosecutor's office has had trouble finding now this evidence because the original conviction is 10 years old and there's been problems in the evidence room. And so even if Skinner wins and DNA testing would be required, which I don't think that that's going to happen because of the case you talked about, I don't see that there's going to be any DNA evidence available, which would be very convenient, right, to say.
What was the evidence against him? I'm just kind of curious.
It was,
blood, right?
yeah, it was blood. There was a lot of circumstantial evidence. Of course, the fact that he was there in the house, and for a lot of these cases, and Skinner included, these are attorneys who are volunteering their services to take people like this up to the federal courts. And one of the criticisms of this case is it's a 1983 civil rights claim instead of a habeas claim, to try to get this evidence out there, because so many of these convictions are later thrown out on appeal. All you need is one of the defendants or somebody sitting on death row to squawk, and then the state of Texas will throw the whole case out. But until they squawk, until they file something, nothing gets done, and presumably these people are being executed without their fair day in court. So I don't know what'll happen.
I guess the one other piece of this is just a couple years ago they had the Alaska case,
Right.
the Osborne case, where they already said there's no due process right to have DNA evidence tested. So I think this is going to devolve into a very technical debate about how you use a habeas claim versus a 1983 claim, and that the only clarification is going to be about what forms of action you might use for what things, as opposed to actually vindicating this guy.
Yeah.
That's what I would think.
I would think so, yeah. I agree.
Okay, if I could take then, we have a little bit of time, if I could take just a couple of minutes to say a little bit about the term in general. One of the things that I find striking is most of the commentators now look at this term, this past term, as the full blossoming of the Roberts Court. And for the first 5 years, most people thought the court was really the Kennedy court, because Kennedy had that position as the swing voter, as O'Connor had been. More generously, some people would say it was the Kennedy-Roberts court. But this past term, it appears that Roberts was much more assertive in the cases, and in fact was in the majority more often than Kennedy was. And Kennedy's pattern had been, fairly long-standing. The other thing is that the Roberts Court is now really poised to be, and has been to some extent, the most conservative court in decades. If you look at the data from the Supreme Court database, the term prior to this, the 08-09 term, the percentage of conservative rulings by the court was at 65%, which was the most conservative since like 1953, since before the Warren Court. In general, it had been running somewhere around 58%. The Berger Court, Rehnquist Court had been more around 55%, so it's slowly ticking, up in terms of increasing in its conservatism. But I think one of the other really important trends that we're seeing is a very activist court, and it's just, on one level, the irony is you have these conservatives who have been complaining about the judicial activists, and this is an activist court. Well, this is one of the most activist courts. In the first year of the Roberts Court, if you recall, most of the decisions, even in the big name cases, they tended to try to decide them very narrowly and not establish any kind of a broad ruling. That's gone. Citizens United is the easiest example of that. They're not afraid anymore to just strike down legislation passed by the Congress, which they used to be a little more deferential. They're not concerned about reversing decades of precedent anymore. I mean, the Citizens United, that case overturned, about 6 decades worth of precedent? Some people would say even longer than that. And then the decisions have been quite broad, as opposed to this narrow grounds that they've been trying to do. And the last thing I want to say, there's another way, another measure, I guess, of judicial activism that doesn't get very much attention. And I was reading this, so a law professor at Paul Gewertz, I forget where he,
I don't remember.
yeah, but he talked about the fact that if you look at the way the Supreme Court normally deals with federal district court decisions, usually they will defer to federal district judges. They're the closest to the case. They know the factual background. They know how the case has evolved and so on and so forth. But what we're beginning to see perhaps is the Roberts Court reaching out to police federal district judges and overturn their decisions as well. And just one example of that, you may have remembered that in the California case involving, was it Prop 8, the same-sex marriage law, the district judge in that case attempted to have the trial televised. And the court jumped in and said, you can't do that, and it was on some technical grounds of you didn't give adequate notice so people could protest whether they wanted this to occur or not. But, that's just another example, I think, of the increasing assertiveness. And there's one other case. Chris, you're going to have to help me with this one. There's a 10th Amendment, potential 10th Amendment case. They just accepted, and it's the most bizarre thing. It had to do with a woman who was convicted under a federal criminal statute when she probably should have been convicted under state law. But what happened was the federal prosecutors said, and she then sought to challenge her conviction on 10th Amendment grounds. And the federal prosecutors said she didn't have any standing to do that. Well, then when the new administration comes in, the new federal prosecutors are saying, no, we agree with her. She has standing to do this. So you have both of the parties on the same side now. The court agreed to hear this case. So the court is reaching out to hear a case when there are no adverse parties. And the only thing I can figure out is that they want to make a bold statement about the 10th Amendment.
This
So-
is the crazy woman trying to poison.
Yeah,
Yeah.
trying to poison her husband's
Husband's
or
lover.
boyfriend's lover, yeah.
And let me just throw in that, in talking to Justice Stevens, one of the most striking kind of manifestations of activism, and it was in criminal justice, and it had to do with the issue of once a defendant has had counsel appointed for them, they are considered represented, and the police are supposed to leave them alone and not go to question them. And Louisiana had gone and questioned this guy. He had counsel appointed for him, but he hadn't seen his attorney yet, and they went and got him to waive his right to counsel and talk to him, and this violated a precedent that Stevens had written 20 years ago. He'd written the majority opinion. But the odd thing was, when the Supreme Court was hearing the argument in the case, the issue was defined very narrowly about how to interpret this. And in the middle of the oral argument, Justice Alito says, you know what? We should be looking at this in a broader way. We should think about whether we want to overturn this whole line of precedent. Neither side had argued or presented or suggested that to the court. He just said we should do this in the middle of oral argument, and the court then required both sides to go back and submit written briefs on that issue, which then created the opportunity for a narrow majority to strike down 20 years worth of precedent to give the police, like Monteo versus Louisiana, I think it was. And I didn't realize how that came up, but there was a reporter who covers the Supreme Court who had called me up. She's National Law Journal, I'm blanking on her.
Marcia Coyle.
What's her name?
Marcia Coyle.
Marcia Coyle had
Yeah.
called me up just to, wanted some soundbite about my Stevens research. And she's the one who told me that when Alito said this during oral arguments, all the
Gasp.
reporters who cover the court, they all just jumped up in their seats because they couldn't believe that this was happening, because it was such a sort of naked, overt way to say, ooh, here's a precedent I don't like. Nobody's suggested overturning it. How can I get it overturned? And she thought that was very uncharacteristic of what she had seen in the court in the past.
So, it's open for your questions, comments.
I'll get it started if I could ask you a question. Talk a little bit about Stephen's legacy. What about his papers? Is he going to hold his papers
I
under
didn't
lock
have the
and
nerve
key?
to ask
You
that
didn't?
because, if you don't want to walk in the door and go, hey, and by the way, can I get an early glimpse at your papers? Because you go and you hope that you're going to get invited back. So you don't know the guy well. You worry about being too pushy.
Yeah.
So he's the kind of person who, it seems to me, is, protective of the court as an institution. He likes his colleagues. So my prediction, just on having spent, 4 hours with him on 2 occasions, is that he would be more inclined to be one to perhaps say, open them up when everyone that I served with has passed away. But on the other hand, now that you see him still wanting to be
Yeah,
actively engaged, would he take a more Blackman-esque approach of
Right.
saying, open him up when I'm gone, and it doesn't matter if Scalia's still around?
Because I think he's a dingbat anyway,
Well,
and I'll have it in my
so-
papers.
So I don't know, because we may have talked about this before I went, like, should I ask him, should I not ask him, but
Right.
I didn't do it. So I really don't know. I don't think he'll be like Souter,
50
because,
years in.
Souter, none of
This
us
is-
will ever see his papers. I don't think he'll be like that. And I also have a sense that while Stevens, for years and years would not do any interviews, none, for years and years, when Gerald Ford died, and Stevens is a great defender of Gerald Ford. He didn't even know him personally, but the fact I think he really appreciates that Ford reached out and appointed a guy that he didn't even know. They didn't even know each other. And so Stevens has been very bothered by, Chevy Chase Saturday Night Live jokes about Gerald Ford. He doesn't like that. He goes out of his way in an interview to always say something about Ford was a very bright, underappreciated guy. But when Ford died, Stevens did a 5-minute interview with ABC News. What's her name? Who used to be over there? Jan Crawford Greenberg. And it was like, it's his first time talking to the press. Well, that's just a couple years ago. And now there's been this tremendous acceleration of his accessibility to the press that may make him lean toward opening up, because I think he likes the attention and the appreciation for being the liberal lion that he never intended to be. And I think he still wants to the very end, battle against the originalists and, make the point. He's very much a believer that judges are put on courts to make judgments, and that they should not try to make them slaves to either a set of rigid rules or to somebody's interpretation of what they think history commands. And, he scoffs at things about Scalia, because, the originalists like Thomas and Scalia would claim to not care about the results All they care about is enforcing the originalist rule, and so they have great contempt for the notion of empathy, for example. And Stevens will say, you know, go back and look, I think it was Boumediene, you know, here Scalia's talking about, oh, if we release people from Guantanamo, this is going to lead to Americans being killed. And Stevens is like, what is that? That's empathy. That's concern about results. That is an admission that you don't really follow this rigid formalism that you claim to follow and that you want to impose on everybody else.
So I was going to ask you, what did you, I mean, you've answered it already to a certain extent, but what does he think about his legacy? I mean, I know what you were thinking about, but what does he think?
You know, he is such a modest person that is a question that would be very tough to get an answer out of him, and the answer would be a very modest, you know, I just want to be remembered as, you know, a judge who tried to uphold judicial traditions and did my best. I mean, he is so modest. But I think that if you look at what he talks about in interviews, for example, that he is going to look back at, for example, some of the Eighth Amendment stuff, Atkins versus Virginia about execution of the mentally retarded, or Roper and juveniles. He's going to look at Lawrence versus Texas, that he didn't write the thing, but he got to decide who's going to write it and whether he cultivated Kennedy, et cetera, et cetera. So I think it really is. And if you look at the sheet I handed out about Miranda, he has been the most staunch defender of Miranda, you know, other than Thurgood Marshall. And his defense of Miranda goes way beyond, you know, sort of if you look at his regular score for criminal procedure generally. And you contrast that with Scalia, whose, you know, desire to get rid of Miranda. So I think, like, Miranda, right to counsel, I mean, he wants to be known as a judge who really appreciates the importance of a lawyer. And so that means defending Miranda. That means defending right to counsel. That means defending the adversarial system, which he really believes in, because he was out there in private practice for years and years. And what a lot of people don't know, he was also doing pro bono prisoner cases and criminal cases and seeing really all areas of law. And I think he wants to be remembered as someone who defended the importance of attorneys and the importance of adversarial system as well.
Is anybody else ready with a question? Can I ask one more question related to the liberty piece? Do you see a similarity between Justice Stevens's conception of liberty and Justice Breyer's conception of this act of liberty that he talks about in the books that he's been writing?
Honestly, I haven't studied it closely enough because, frankly, you know, Stevens has written, you know, 1,300 opinions. So I've just been so overwhelmed that it's only in this year, really, I've been doing this for 4 years, that I really started to appreciate this liberty aspect. There was an article by one of his former law clerks. They had a symposium on Stevens in the UC Davis Law Review, which just came out earlier this year, who really focused on that liberty thing. And it made me, because I'm interested in prisoners' rights, go back to one of the very first prisoner cases that came to the court when Stevens was there. And right out of the gate, he was talking about liberty as something that prisoners maintain as a right, and we just have to define how much of it they have. And it was very much a natural rights concept of liberty, because he was criticizing the court for saying that, you know, there are state-created liberty interests, or you have to find the liberty interest someplace. And, you know, he's practically quoting the Declaration of Independence. We're endowed with it was very interesting for me to have the realization that this goes way back for him. And I'm not sure that that's been linked up, the fact they're both using that term liberty. And I have not looked closely enough at Breyer, and I'm not even sure I understand Stevens enough to link that up, but it is an interesting question. Clearly, they're not going to apply it the same way, because Stevens has a broader, you know, more assertive conception of individual rights, and Breyer's probably a little more pragmatic in a lot of individual cases.
And Breyer's position, back to the McDonald case, when you said, well, he looked at the issue from a pragmatic standpoint, that is his approach. But he also does not want to be defined and have the Constitution defined in these rigid,
Right.
you're a originalist or you're a living Constitution. He says it's an act of liberty that requires us to interpret, that the founders left for us this document that to help us learn what our liberties are and how we define how we live as a society and all this stuff.
And of course, one of the interesting things sort of to watch is how Scalia, came on as the originalist, and he's the one arguing, because Rehnquist rejected originalism as the thing to follow. I mean, he said that in a speech to the ABA. I mean, he may end up with the same result, but he rejected that as having to be the guiding principle. So Scalia's alone. Then Thomas comes on, right? Now we got Alito. He's clearly with them too. Roberts probably isn't quite over there philosophically. And so when you see in Heller, the whole case is written as a debate about originalism, that they now have a critical mass on the court to start to define the terms of interpretation in some way, that you see the counter reaction. You see Ginsburg giving speeches critiquing this. You see Souter's commencement address at Harvard. He was never outspoken,
Right.
which again is this critique of originalism. Stevens critiquing it, leaving the bench, and Breyer now writing books about it. I mean, we really have now a mainstream debate about how we interpret the Constitution, really public, meaningful, repetitive, and important.
Even O'Connor was on the non-originalist side.
Oh, she was non-originalist.
She would debate Scalia,
Right.
in the opinions as well.
But she hasn't, I don't know, if
Not since.
post-court, she hasn't focused on it, but
She's so
clearly.
focused on the judicial election
Yeah,
issue.
I would
but
say the
in-
originalists are just those three
Right.
now, with Roberts going to end up resulting with them on many occasions, as will Kennedy.
I remember, I don't know if you've gotten to this one, but there's that case from the early 80s, Michael M. It was a case about two teenagers who had sex.
Statutory
Right,
rape.
statutory rape, and,
Yeah.
and only the male was culpable. In other words, there was an age of consent for females, but not for males. And the whole case, basically, everyone, both in the majority and the dissenting side, dealt with issues of equal protection and all of those. Should it be strict scrutiny or something less? And that's basic. And the definition of intermediate scrutiny and things like that. And then you get to Stevens' dissent. And his dissent is all about liberty.
And he rejects the three-tier
That's
equal
right,
protection
absolutely.
approach
He said,
completely.
This
It's
is a
never like
liberty
that.
instance. This is an issue of
Right.
liberty, and not liberty to be, free from jail kind of liberty, but this general liberty interest. And you can
Right.
see that. And that was what, 1981, 82.
Yeah, and-
So that's pretty early on.
And so what I found
is
is even if you go back to 76 and look at
He's
Meacham
already doing
versus
that.
Fano, and I had not realized all this. I hadn't noticed because he's been trumpeting a very individual view. I mean, Stevens says there is only one equal protection clause, not three, and that sort of thing, which frankly, we get so preoccupied teaching the things we were taught in sort of a template of what most of the court does, that I didn't pay that much attention to him in particular on equal protection until more recently, and that's
Michael M. case
exactly
was a good
right.
one,
Yeah.
I just wanted to ask, in the Skinner case, actually, if you thought that was more a product of poor legal representation than it was anything else? Because it sounds like from what you presented today that the case was advanced on the wrong issues.
Yeah, what I could find from reading about the preliminaries of the case is this was a public defender represented case out of Texas. And then once he gets on death row, he makes a lot of noise with the media that all I want is DNA testing, all I want is DNA testing. And then you get all these other lawyers involved who then push his case up through the federal system. So yes, you're exactly right. At least Skinner's argument is this was partially a question of, shoddy legal advice. And of course, I think there are 12 other cases in Texas that happen to right around the same time that are all coming down the pike looking very similar. And of course, this is nothing new to you. We've seen these cases come out of Texas and to a lesser extent Virginia as well.
Two big death
The
penalty
two
states.
big death penalty states. Turns out it's I think this is my personal opinion, nothing that the Skinner case indicated, but it is very, very expensive to have the death penalty as a form of punishment in your state. And when states don't, spend the money on legal representation in these death penalty situations, then ultimately it costs them more, right? So you kind of rob the public defender service to pay for all of these, capital offense legal representations, and then you just can't afford the bill at the end of the day. And so they start cutting back on the funding for public defenders. And other states do this too, but it's particularly literally dire in a place like Texas or Virginia. So
Thank you.
I don't know the timing of the Skinner case, but the other reason this arises is because there will be advances in DNA testing, so that the capability of those tests are different after you've been on death row a number of years than they were at the time of your trial, which is an additional
also
complication. And I don't know how long he's been in, but that arises a number of times as well.
and cheaper. They've become significantly cheaper just in the last 5 years because of the scientific advances. And he's been on for 10 years. And so he exactly hit that period of time where, you had places like New York trying to create these DNA databases, and financially they just couldn't do it. It sounded like a great idea. You take every single person who's committed a felony, stick their DNA into a database, and then it should be easy because, of course, if you right. So if you commit one crime, of course you'll commit, and it was just too expensive. This is about 12 years ago. New York just could not afford to get the project up off the ground. And Skinner came along, right about at that time, and then advances came out, about 5 years, 2005 was when a lot of its scientific advances came out, and the cost of DNA evidence testing went from, for one piece of evidence, went from something like $5,000 down to about $200. Just since 2005. So now that's why all of these cases are coming down the pike, I think.
What's also interesting is the history of who wants DNA evidence is kind of interesting as well, too. In the mid-'80s, when DNA evidence first started to become a possibility, it was defense attorneys who were arguing on things like Fourth Amendment, unreasonable search and seizure, we shouldn't be able to do this and things like that. And prosecutors were all gung-ho about saying, get the DNA evidence, get the DNA evidence. Well, it turns out that more people were actually exonerated from DNA evidence than convicted, so it's completely turned around. Now it's the defense side that wants DNA evidence, and the prosecutors are doing everything they can to keep it out, because basically the DNA evidence becomes the critical issue for juries. If the DNA evidence says it was them, they're guilty. If they weren't there, they're not guilty. And where the prosecutors
Thank you,
used to be,
CSI shows.
That's right. I mean, seriously, where the prosecutors used to be able to build up a case based on circumstantial and sometimes even other physical evidence, they cannot do it with DNA evidence at this point. So it's real interesting. There is a prosecuting side now that's trying to keep it out, where it was the defense attorney side that was trying to keep it out originally.
Scott, I want to ask you back to the McDonald case. So they've sent it back now to
As far
the
as I know.
Seventh Circuit.
Right.
Any idea when that's going to be decided? Do people have any inkling of how that is going to ultimately be decided? And what do you think? Are there other cases already kind of in the pipeline now that are trying to?
There's plenty. I mean, the Seventh Circuit had upheld the Chicago ban as constitutional. Now they've been given sort of a guidepost, I guess, with the new standard that it's a fundamental right, and the law would have to be justified with the compelling state interest. And if you talk about the crime rates, obviously, but the exact wording of the statute deals with registration and re-registration.
And I know I had read that Chicago's attorneys were working on how can we conceptualize this in compelling interest terms. So, but I think pretty much everybody, at a minimum, is probably going to predict that in light of what was permitted in Heller, that is going to be permitted as the minimum in the state and local level, that is law-abiding citizens owning a handgun in the home. What beyond that is a right is the complete unknown, I think.
I had a question for Mark about the animal cruelty case. You may have mentioned this in your presentation, but the wording of the statute, and you mentioned that it was overbroad. I was wondering if you could maybe talk a little bit about that, the exact wording of it, and how could it be written in a more narrow sense?
Well, that's the problem. How could it be written? I mean, the law says it is a federal crime, a felony, to knowingly sell depictions of animal cruelty for commercial gain. And again, if you have a picture of deer season, and there's a guy who's got a deer on his back that he just shot, is that animal cruelty?
To some people it is.
And Chief Justice Roberts said this easily, you could get a prosecutor who easily could say this is, and so that was far too broad. They didn't say what would be more narrowly tailored. But it's the same thing. They always come up with this with obscenity issues. I mean, every single time they've tried to keep internet porn out of the hands of kids, and the Supreme Court keeps saying you're just too overbroad. You've got to make this more narrow. And Congress has a real problem with that. I think in part because it's difficult to come up with that language, and I think in part because Congress likes to make a stand to say, no, we want to be broad on this, because that's how many of them on both sides of the aisle win elections. And so it's really difficult for Congress to come down with a more narrow kind of an issue. The court didn't give them guidance. They just said, this is too broad, you got to be more narrow.
It's a good example to use in class. I always have trouble with students understanding the narrowly tailored to serve the compelling state interest, but that's a good example that gives them sort of an
Well, it is,
interesting
sure.
way.
You can just say, I mean, here's a picture of a guy who's got his deer on the back of his pickup truck or something like that. Is that animal cruelty?
We have a section in our newspaper in Western Maryland, which is very rural, and there's a whole section of hunting with the people with the deers and so forth.
Yeah, and it's,
Students would understand
Yeah.
that.
Well, I think we've actually gone past our time, so thank you for staying with us, and we enjoyed doing it.
Good job, boys.
So in Alaska papers, that people with grizzly